A core constitutional function, the signature of the President of the United States, has been outsourced to automation, systematically compromising the legal legitimacy of an entire previous administration. Overnight, a nuclear-level directive was dropped, not against policy, but against procedure. 92% of all executive actions, pardons, directives, and judicial appointments signed by Autopen have been legally terminated. This is not a partisan policy fight. This is a challenge to the constitutional foundation of the government itself. The ultimate implication, now being debated in hushed tones across the federal judiciary, is this. If the very commission securing a lifetime seat on the Supreme Court is now deemed invalid, what else across the vast architecture of the federal court system is about to collapse? Stay with us as we break this down in our in-depth discussion right here on News Focus Podcast. And if you find our reporting valuable, please hit the like button and subscribe to support our channel. We truly appreciate it. Okay, so let's unpack this. We have to start with the sheer political and, I guess, administrative audacity of the timing here. We're talking about President Trump posting a legal directive late at night during a period when most of Washington, D.C. was, scattered, disengaged.
Enjoying a holiday lull, yeah.
Right. This was a surgical surprise attack.
Oh, it was more than strategic. The timing was calculated for maximum systemic shock.
How so?
Well, think about it. When you launch an action of this magnitude, one that effectively voids nearly everything the prior administration did, you have to ensure the opposition can't coordinate.
You can't give them time to build a defense.
Exactly. No legal defense, no political counter-narrative. By releasing this directive late at night, during a federal holiday week, Trump guaranteed no leaks, no slow walk, no time for the opposing party's legal machinery to even brace itself.
And based on the initial reporting, the immediate result of that surprise attack was, it was pure institutional chaos.
Chaos is really the only appropriate term. When that post went live, it wasn't just phones ringing. The system essentially experienced a digital earthquake.
I can only imagine.
High-level staffers were pulled out of bed, cabinet officials were jumping on emergency conference calls, and the initial reaction among these power brokers was just disbelief. Then, almost immediately, panic.
So this wasn't a policy debate?
No. Congressional aides weren't debating policy points. They were whispering, is this real? Did he actually just void everything we spent 4 years building? Washington woke up to an instant, completely unprecedented constitutional crisis. And it's focused entirely on the authenticity of a signature.
And that panic it's entirely understandable once you grasp the specific legal force of this directive. The new administration didn't just reverse or repeal the previous administration's actions. They declared that every document touched by an Autopen was terminated. We need to spend some serious time defining that word terminated, because it is the crucial legal key to understanding the severity of all this.
This is exactly where we shift from political theater to constitutional law. And the distinction is, it's critical.
Okay.
When we look at a typical administrative reversal, we usually see words like repeal or rescission.
Right.
So imagine a new EPA rule. A new administration might rescind it. That means they acknowledge the old rule existed, it had legal force during its tenure, but they're canceling it moving forward.
So the history of the action remains intact, even if the policy itself changes.
Precisely. The document, the order, the action, it's a legal fact that it happened.
But that's not what happened here.
Not at all. Here, Trump employed the strongest possible executive language. He declared that these Autopen-signed documents are of no further force or effect.
Which sounds much more final.
It is. This declaration is foundational because it asserts that the documents were never constitutionally valid in the first place.
So to put that in simpler terms for everyone listening, the Trump administration is arguing the document wasn't just canceled. It was legally erased from the record as if it never even happened.
Exactly. The term we use in law for this retroactive voiding is ab initio.
Ab initio.
Meaning from the beginning.
Yeah.
The argument is, if the constitutional requirement for presidential action, the personal signature, was violated, then the document is void ab initio. It's not just a cancellation. It's a claim that the action itself lacked the legal authority to ever exist.
And that explains the panic.
This is why the Department of Justice, the White House counsel's office, and frankly every federal agency are scrambling right now. If the Autopen approvals were never valid, then anything built upon those approvals just collapses. The whole structure falls apart.
And what makes this so monumentally destructive is the scope. We have this jaw-dropping, almost unbelievable number, 92%.
It's staggering.
Internal reviews cited by the new administration claim that 92% of executive-level approvals, orders, commissions, and authorizations were generated by an Autopen, meaning they were mechanically replicated, not personally signed or even reviewed in real time by the president.
That 92% statistic isn't just a political headline. It's a terrifying measure of institutional failure. It suggests that nearly the entire foundation of the previous presidency's administrative output was built on a process of mechanical replication. It lacked the required personal, verifiable, constitutional action.
Let's elaborate on what that 92% actually touches, because it's easy to dismiss this as just, bureaucracy. What kinds of high-level actions are now legally in question here?
It permeates every pillar of government. I mean, think about some very specific examples.
Okay.
1. Judicial appointments. We're talking hundreds of district, circuit, and specialized court commissions.
In hundreds. Wow.
2. Regulations. Major agency rules implemented by the EPA on climate, the DOJ on enforcement priorities, HHS on public health mandates. The big stuff.
National security.
Absolutely. High-level personnel appointments,
Yep.
authorizations for sensitive operations, perhaps even some national security directives that require a presidential signature. Then there are pardons.
Yeah.
High-profile, specific pardons granted to federal offenders.
And even ambassadors, cabinet members.
Submissions for ambassadors, cabinet-level secretaries, heads of major federal agencies, the whole shebang.
So the foundation of the presidency was automation, not personal action.
Mhm.
And that now subjects nearly every major decision to this termination order.
Yes. The single unifying question now echoing through every federal hallway is this. If the Autopen signed it, does the action still legally exist now that it has been terminated?
That 92% figure is the fuse.
It's the fuse burning toward the biggest legal showdown of the decade, because it threatens the operational legitimacy of an entire presidential term, moving far beyond any typical policy conflict.
So we've established the 92% figure means the entire government foundation is shaky. Now, where do we see that structural instability create the most immediate critical constitutional danger?
Well, that brings us directly to ground zero.
The judicial legitimacy crisis, specifically focusing on the highest court in the land.
Yes. The focus immediately snaps to Justice Ketanji Brown Jackson. Her name is now central to this crisis because early internal reviews strongly suggest that her commission documents,
The legal papers themselves.
the legal papers that actually bestow the lifetime authority of a Supreme Court justice, they were Autopen signed, not personally signed by the president.
This takes us directly to the fundamental law governing the federal judiciary. What exactly does the Constitution demand of a Supreme Court commission? Is it just paperwork?
No, this is not just administrative paperwork. This touches on Article 2, Section 2, the Appointments Clause. It requires the president to nominate and by and with the advice and consent of the Senate to appoint all judges of the Supreme Court. While the ceremony is public, the legal act of appointment is sealed by the commission. And that commission must bear the personal, authorized signature of the president and the seal of the United States.
So the use of an Autopen, even if it's generally authorized for lower-level documents, it hits a hard constitutional wall when we talk about a lifetime judicial appointment.
Absolutely. Supreme Court commissions are a constitutional act. The law distinguishes between ministerial acts, routine paperwork, and constitutional acts, which require the highest level of presidential personal involvement.
So this is non-delegable.
Legal precedent, stemming from very early rulings on presidential power, has historically held that lifetime commissions, especially for the judiciary, are among the non-delegable duties. The signing cannot be treated as a purely mechanical function. No exceptions, no proxies, and certainly no blanket mechanical reproductions are permissible for this specific foundational act.
So if the signature was placed by staff using the Autopen without explicit, documented, real-time authorization from the president for that specific commission,
Then that appointment is legally vulnerable.
it means the legal foundation for her lifetime seat is questionable.
That is the precise legal exposure and the potential consequences. This is why political commentators are calling this the biggest judicial legitimacy crisis since the mid-1800s.
That's a huge statement.
It is, because the moment you successfully challenge the constitutional validity of the presidential act that created the office holder, you jeopardize the holder's entire tenure.
Okay, before we dive deeper into the modern crisis, let's use that historical comparison you just raised. What happened in the mid-1800s that even remotely compares to this?
We're primarily looking at the fallout immediately following the Civil War during the Reconstruction era. specifically regarding judicial appointments and even the tenure of certain justices.
So, a highly politicized time for the courts.
Deeply politicized. Congress was actively working to manipulate the court's size and composition, a concept sometimes called court stripping.
Can you give us a concrete example?
Sure. The case of Ex parte McArdle in 1869 is a great, if a bit technical, example. Congress feared the Supreme Court would rule against the constitutionality of Reconstruction legislation. So they actually revoked the court's jurisdiction to hear certain appeals while the case was already pending.
I just changed the rules in the middle of the game.
They did. It was a direct, systemic challenge to the court's functional legitimacy and its independence. Now, that was a legislative attack, but the constitutional stress was similar, an entire branch of government being functionally crippled because its legitimacy was being challenged.
But this is different.
The current Autopen crisis is unique because the challenge comes from within the executive branch itself, alleging a structural constitutional flaw during the appointment process.
That context is vital. So let's return to the modern crisis. The ripple effects of questioning Justice Jackson's commission. They sound catastrophic. If her commission is deemed voided by this termination order, what happens to her body of work?
The magnitude is staggering. If that signature is proven unauthorized and thus voided, every single ruling she has participated in since her confirmation becomes open to immediate legal challenge.
Every single one.
Every one. Based on the principle of judicial authority, think of all the pivotal 5-5-4 decisions where she might have cast the deciding vote. All of those rulings spanning years become subject to legal motions questioning the court's competence to issue them in the first place.
That would mean a cascade of challenges pouring into the lower courts, all trying to exploit this legitimacy loophole.
It would. And this tension is concentrated right now inside the Supreme Court building itself, because the situation creates an unprecedented conflict of interest.
That's the extraordinary scenario here. If a case reaches the Supreme Court that directly questions the legality of her own appointment, her commission, she would technically be forced to recuse herself.
She'd have to. She has a direct personal stake in the outcome.
So what's the rule on that?
Well, the general rule for judicial ethics and due process requires recusal when a judge's impartiality might reasonably be questioned. A judge ruling on the validity of their own commission is the textbook example of a lack of impartiality. So she must step aside.
And the decision then falls to the remaining 8 justices.
The other 8, yes.
Is there any precedent for this? For the remaining justices ruling on the validity of one of their own members' seats?
Formal precedent for this specific type of constitutional voiding challenge is extremely thin, which is why legal analysts are calling this the most explosive judicial challenge in 150 years.
So they're in uncharted territory.
Essentially, yes. The justices would be required to act as constitutional referees on the executive branch's execution of the Appointments Clause, where one of their own is the subject. They'd look at historical practice, the text of the Constitution.
Imagine that pressure cooker. 8 justices determining the constitutional validity of the 9th. The political pressure would be unbearable.
It would be seismic. And the outcome is definitive. If her commission is ruled invalid, if the constitutional procedure was deemed flawed and void ab initio, the court seat becomes vacant.
Vacant how?
By operation of law. It requires no impeachment process, no resignation. It simply means the seat never legally belonged to her because the constitutional steps weren't properly adhered to.
This is, without exaggeration,
The political equivalent of a nuclear event for the Supreme Court.
and that outcome on the Supreme Court would immediately cascade down into the wider legal system. If the logic that the Autopen invalidates Justice Jackson's commission holds,
Then the same logic extends to hundreds of other federal judges,
district, circuit, appellate judges,
all appointed during the same period who may have also received Autopen-signed commissions. The scale of this appointments crisis is truly enormous.
so it's not one judge.
We aren't talking about one isolated case.
Yeah.
We are potentially dealing with over 300 judges whose commissions may also be legally challenged if they relied on the same automated signature process.
300.
And this isn't a localized flaw. It's a systemic weakness across the entire federal judiciary that really compromises the separation of powers.
And this brings us to the core legal principles defining this collapse. Specifically, this doctrine the Trump administration is using, fraud vitiates all. What does that mean?
It's a legal maxim, fraus omnia vitiat. It means fraud spoils everything. Now, the argument here, as framed by the new administration, isn't necessarily criminal fraud. It's that the unauthorized mechanical signature constitutes a constitutional fraud or a critical breakdown in the legally required process.
So if the process was invalid.
Then the resulting appointment collapses.
But surely the courts have mechanisms to prevent total chaos, right? There has to be some legal doctrine that prevents an entire judicial system from imploding simply because of a signature error.
Absolutely. And this is the necessary legal complexity for you to understand. The counter-argument that will immediately be raised by legal defense teams is the de facto officer doctrine.
Okay, explain that for us. What is the de facto officer doctrine?
The de facto doctrine is essentially a shield. It's designed to protect the public from the exact chaos we're describing. It holds that where an official performs duties under color of a known election or appointment, meaning they appear to be legitimately holding the office, their official acts are considered valid regarding the public and third parties.
Even if it's later discovered their appointment was flawed.
Even if it was technically flawed or irregular, yes.
So the argument is they sat on the bench, they wore the robe, the public believed they were a judge, so their rulings should stand.
Precisely. This doctrine is the traditional safety valve that keeps the government running even when bureaucratic errors happen. But the unique danger posed by the Trump administration's move is that they have declared these Autopen acts terminated, meaning void ab initio. They are arguing that the flaw is so fundamental it touches upon the constitutional grant of power itself that the de facto doctrine can't save it, because the officeholder never possessed the requisite constitutional authority in the first place.
That is a deep legal chasm. It means the entire crisis hinges on whether the Supreme Court ultimately sides with the de facto doctrine of administrative necessity or the ab initio argument of constitutional procedure.
It's a contest between pragmatism and foundational constitutional purity. The Trump administration is betting that the constitutional flaw, the failure of the president to personally execute his duty, is too severe to be waived by mere administrative convenience.
So what does this mean in real terms? Why should someone outside of Washington care if a district court judge's commission is questioned? You mentioned chaos, but let's make that concrete.
It is absolute chaos for the average American who is affected by the federal court system. And that's more people than you think. Think about the thousands of actions these hundreds of judges have presided over.
Okay, like what?
Well, first, criminal convictions. Defense attorneys are now obligated to challenge any conviction decided by a potentially illegitimate judge.
And if they win?
If the conviction is thrown out, thousands of inmates across the country could have their sentences vacated or their cases reopened.
A huge mess.
A huge mess. Then there are regulatory rulings. Injunctions that halted major infrastructure projects, rulings defining environmental law, decisions on intellectual property. All of that could be questioned, throwing industries and local economies into turmoil. Not to mention basic constitutional challenges, habeas corpus filings would surge.
The systemic impact would be immediate and debilitating.
Absolutely. Federal dockets would choke instantly under the weight of motions challenging judicial authority. Law firms would establish entire practice groups dedicated solely to reopening cases based on this single signature issue. This isn't just paperwork. This is the mechanism of justice grinding to a halt because the underlying foundation of judicial authority has been rendered uncertain.
Let's pivot now to the administrative root of the problem and the massive legal bind the former administration now finds itself in. This takes us to the legal standards for Autopen use and what looks like a massive perjury trap that President Trump laid with surgical precision.
Right. So the federal law regarding presidential signatures it's generally rooted in practical necessity. Historically, Congress and the courts have recognized that the president can't possibly sign every single piece of paper generated by the world's largest executive branch.
Of course not.
So the president can delegate the mechanical act of signing a document. That is permissible.
But the key is that he cannot delegate the authority itself.
Precisely. For any document requiring presidential approval, he must demonstrably, personally review, approve, and authorize the action beforehand. Delegation of the mechanical act is fine. Delegation of the constitutional duty is not. And crucially, that authorization must not only happen, it has to be provable.
Provable how?
Documented, traceable, through internal White House logs, digital audit trails, or testimony. This documentation is the former administration's sole legal defense against this termination order.
And this brings us to the central problem, the cognitive challenge to that documentation. which was first raised prominently in Robert Hyrd's investigative reports.
This is where the legal standard meets unavoidable political reality. The Hurd investigation reports. They raise serious doubts about the former president's memory and awareness regarding the details of government action.
I remember those reports.
The report stated plainly that the president did not remember significant details of his own activities. They suggested he was, quote, mentally logged out for years in terms of tracking the minutiae of government action.
So if the legal standard requires proven, documented, traceable personal review for 92% of all actions, but the president's own cognitive records suggest he lacked the capacity to reliably track what his staff was signing.
The legal defense evaporates.
Yeah.
It creates a catastrophic, dual-layered legal defense failure.
So what are investigators looking for now?
They're tasked with digging into the White House record. They need to find specific documentation. Things like, 1, digital workflow logs. Did a document move through a system requiring a presidential password or a biometric sign-off before the Autopen was activated?
Or authorization memos.
Exactly. Were there blanket memos issued detailing which categories of documents could be Autopen signed? Did they clearly define the limits? And maybe most importantly, staff testimony. Can senior staff credibly testify under oath that they personally presented each of the 92% of documents to the president, confirmed his understanding, and received explicit authorization before using the Autopen?
But given the Hurd report's claims of limited recall, any staff testimony claiming specific personal authorization for potentially millions of documents, it becomes immediately vulnerable to cross-examination.
It becomes almost impossible to defend. If the president lacked the capacity to track what staff was signing, if he simply waved through massive piles of paperwork without engaging in the required constitutional review, then millions of pages of government action may have been carried out without a constitutionally competent president overseeing them.
And the reports of a chaotic workflow don't help.
No, that compounds the issue by eliminating potential audit trails.
And this vacuum of documentation, coupled with the cognitive uncertainty, leads us directly to you have to call it the genius and cruelty of the perjury trap laid by President Trump.
It was a move of surgical precision. It turned a constitutional dispute into a potential criminal investigation. Trump explicitly warned that if the former president now claims he personally authorized the Autopen documents, and the evidence, or lack thereof, suggests he did not, or can't prove he did, then perjury charges are immediately on the table.
Why does this bind him so legally? Why can't he just say, I trusted my staff and I generally authorized everything?
Because the constitutional act of appointing a Supreme Court justice or issuing a pardon requires more than a general authorization. It requires specific, personal review. The impossible situation is a forced choice. It's a classic legal scylla interribdis.
Two bad options.
Two very bad options. 1, deny involvement. If the former president denies personal involvement in the signing of the 92% of documents, he effectively admits that his presidency operated on unauthorized voided signatures, which entirely validates Trump's termination order.
And the other option.
2, claim involvement. If he claims personal involvement and authorization, investigators will immediately demand the proof, the documentation, the logs, the testimony, which his own cognitive record makes extremely fragile to defend. A failure to produce that documentation could lead directly to federal perjury charges or charges of making false statements to investigators.
So the Department of Justice has no choice but to investigate.
Correct. The situation creates a clear legal mandate for the DOJ. They must evaluate whether false statements were made. If the president signed off on these actions, knowing or recklessly disregarding that he couldn't prove his personal authorization, that falls squarely into the realm of criminal misconduct. This perjury trap profoundly escalates the fight. It shifts the focus from whether the actions were procedurally void to whether the former president engaged in criminal deception about his participation.
That level of escalation forces a legal battle unlike anything we've seen in modern history. It's not just about the legality of a policy anymore.
No, it's an investigation into the machinery of power itself.
Into the legitimacy and honesty of the procedures used by the Oval Office.
Yes. If the core instrument of presidential action, the signature,
Yeah.
was abused or misused due to incompetence or intentional misrepresentation, then the entire structure must be reviewed, regardless of the political cost.
Okay, we've detailed the crisis, the legal binds, the sheer scale of the appointments affected. What happens now? What is the immediate legal storm forecast for the coming weeks?
The first expected step is a formal, decisive response from the Department of Justice. They simply cannot let this vacuum of authority persist.
They have to say something.
They have to issue a formal legal opinion clarifying how Autopen approvals will be treated under federal law, specifically in light of this termination order and the high constitutional stakes of judicial commissions. That opinion will serve as the legal blueprint for every federal agency and every court challenging these terminated documents.
And while the DOJ deliberates, the former president's legal team is already preparing its counteroffense. What's the defense strategy look like?
It's a multi-layered defense. It'll be focused less on proving personal authorization for every single document and more on institutional necessity.
Meaning?
First, they'll frame Trump's move as an unprecedented politically motivated action. Second, and this is the quiet admission being reported, they know they lack consistent documentation for many of the 92% of approvals. So their legal response will lean heavily on the concept of administrative continuity.
And implied necessity.
And the implied necessity of delegation to prevent the government from simply ceasing to function.
They will argue that without the Autopen, the bureaucracy would have failed.
Exactly. They'll argue the sheer volume of documents required delegation, and that there was a presumed high-level authorization, even if the low-level proof is missing. They'll also argue that the de facto officer doctrine is paramount, and that voiding hundreds of judges is a greater harm to the republic than a procedural error.
Meanwhile, the Trump administration isn't just waiting around. They are moving on to the offense in the courts.
Oh, they're preparing emergency filings. They will seek immediate judicial confirmation of the new president's constitutional authority to void improperly executed documents. They're trying to establish the precedent that the termination order itself is a valid exercise of presidential power.
To get the court's stamp of approval before the other side can mount a real defense.
Precisely.
So we should prepare for an absolute flood of legal challenges hitting the federal dockets simultaneously.
The dockets will explode.
Yeah.
You will see several specific types of lawsuits probably all at once.
Like what?
One, injunction requests, filed by agencies, groups, individuals affected by voided regulations seeking to temporarily halt the termination. Two, writs of quo warranto.
Which are?
They're challenges to the authority of an officeholder. These will be filed against the hundreds of judges whose commissions are now questioned, demanding they show by what warrant they hold office.
Right.
And three, of course, appeals of convictions from defense attorneys.
So every decision, every ruling, every temporary injunction in the next few months will carry this immense weight of determining the future operational structure of the American government.
That is the ultimate gravity here. The next steps will determine whether the legacy of the previous administration is ultimately viewed as legally flawed in its internal execution, a matter of poor administration, or if it is historically branded as historically invalid due to operating without constitutional checks.
The difference between a political error and something much more fundamental.
A fundamental constitutional betrayal, yes.
Let's just zoom out for a final moment, because the implications here go far beyond the domestic legal fight. This is about the collapse of an entire governing structure, the Autopen presidency crisis.
This crisis reveals a vulnerability that has global ramifications. We live in a world reliant on the stability of U.S. executive power.
And our allies are watching.
They're watching with visible confusion. They're asking how a presidency so dependent on automated, potentially unauthorized signatures stayed hidden for so long. Every treaty, every international agreement, every diplomatic appointment signed during that period now carries a shadow of legal uncertainty.
And markets.
Global markets are studying the fallout closely. Uncertainty in regulatory stability and high-level appointments translates directly to risk premiums.
So Trump didn't just overturn a few regulations. By challenging the signature, he may have fundamentally rewritten the historical record of the previous presidency itself.
That is the monumental achievement of this directive. Everything the previous administration touched, federal appointments, high-level pardons, major regulatory mandates, the distribution of agency power is now subject to revisit, subject to legal challenge, and potentially subject to being voided. This is the unraveling of an entire legacy in real time, all centered on a rubber-stamped, unverified signature. The next few weeks, as the DOJ responds and the first waves of cases hit the courts, could reshape the legal and political landscape more profoundly than any policy debate could have ever achieved. Thank you, Alex, and thank you to our listeners.
That's all for this deep dive, but it leaves us with one haunting question. If the guardians of the rules are the first to break them, who is left to protect the game?